Hi students, let's start a new video and in this video we will learn about conciliation, Lok Adalat, Ombudsman, Lokpal and Lokayukta. Let's start the section. Students, first we will learn about conciliation and this conciliation is mentioned in part 3 of the Arbitration and Conciliation Act 1996. And what is the term means? This conciliation means what? It means the setting of disputes without litigation. And now we will look into what is the connection in between, or do there any connection between mediation and conciliation? We can say that actually this mediation and conciliation are almost same, but there is a difference in the role played by the mediator and conciliator. So what is the difference? We know that what mediator do? He only facilitates a platform for the parties to reach out to a solution, where conciliator will involve into the matter and he will suggest solutions to the parties to solve the problems. So the difference is mediator is only a facilitator. He only facilitates a platform and the party themselves resolve the problem. But a conciliator is bit different. He involves into the matter and he also suggests a potential solution to the parties to solve their problems and to settle their claims and disputes. Now we will check it out whether this conciliator has the power to draft a settlement agreement. Yes, the conciliator can draft a settlement agreement and it is provided in Section 73 Clause 2 of the Act 1996. 1996 Act means the Arbitration and Conciliation Act 1996. And once the parties signed in that agreement, which is drafted by the conciliator, then it becomes binding on the parties, and this is regulated by Section 73 Clause 3. And now we will discuss a case, that is Harish Deram Thakur versus State of Maharashtra. And students, you need to mention this case while appearing in the exam, and if you have to face the question related with this conciliation. So this case is Harish Deram Thakur versus State of Maharashtra, and in this case the Supreme Court held that, see, once the settlement agreement is come out from a conciliation process, then it will have the same effect like an arbitral award. Means conciliation settlement will be like an arbitral award itself. Means it has the power of a decree passed by a court or court of law, and it is enforceable too. Enforceable in the sense like, see, the parties are not ready to obey the rule, then the court has the power to enforce it. So now we will learn about Lok Adalat, and we can say that the Indians can proudly say that yes, this Lok Adalat is a contribution from India to the world legal jurisprudence. So it's a contribution from Indian side. And what this Lok Adalat means? It means people's court. So Lok Adalat means people's court. And see, even in ancient time also we heard about panchayath, and we can call it as Nyaya panchayath, and it was there in the villages to so and these law Nyaya panchayats were solving the disputes between the villagers. And that same philosophy is adopted in Lok Adalat, where the people who are directly or indirectly connected with a particular dispute will gather together and will have discussions and will settle down the problem. This is the same things what were happened in Nyaya Panchayat. The same is happening in Lok Adalat also. And the main aim of establishing a Lok Adalat is just to reduce the burden of normal courts, because the people are, if everybody has approached the court of law, then the burden of the court will increase, and at the same time, the people will need to be wait a lot of time to get or resolve their problems. So the main aim of establishing this Lok Adalat also is to reduce the burden of the normal courts, and to provide a solution to the litigants at the earliest. Now we will check it out who all includes in this Lok Adalat. This Lok Adalat will have a chairman, and what is his qualification? This chairman should be uh, he should be either a sitting judge or a retired judicial officer. And additionally, in this Lok Adalat, apart from this chairman, there are two members also, and one will be a lawyer and the other will be a social worker. Now we will check it out. What is the jurisdiction of Lok Adalat? And we can say that almost everything, like a civil and compoundable criminal disputes. Compoundable criminal disputes means that criminal disputes that can be settled down or can be compromisable. Uh, Not like minor criminal offences. So all these civil and minor criminal offences can be entertained by the Lok Adalats, and even this can be done if the case is pending before the court of law, or even at the pre-litigative stage itself. So now we will check it out. What are the benefits of Lok Adalat? So the very first benefit is there is no court fees. Like, see, if we said that we can approach the Lok Adalat if the matter is pending before the court or at a pre-litigation stage. Suppose if the matter is already before the court, and but the matter and yes, of course, the matter is before the court means the parties have already paid their court fees. And if the matter is referred back to Lok Adalat and the matter is been settled down by the involvement of Lok Adalat, then the parties can claim for their court fees back, and they are entitled to get it from the normal courts. So we can say that no court fees is the very first benefit of Lok Adalat. And the second one is, yes, of course, there is no much strict procedures of law to be followed. And the third one is, even the parties are very free to, they can even interact with the judge, which is not at all possible in our regular court of law. So here the parties itself can convey their dispute directly to the judge. And the final one is, yes, of course, the decision passed by the Lok Adalat is like a decree itself. So the parties can approach to the court if one of the parties is not ready to obey the judgment. So we can say that the judgment passed by the Lok Adalat is same like a judgment passed by the normal court of law, and this decision is binding on both the parties and it is enforceable before the court of law. Students, so now we will look into ombudsman, the term ombudsman. So, first of all, it's a Swedish or Danish term and it means representative. Ombudsman means a representative, and ombudsman can be appointed by legislature or executive. And of course, his duty is to investigate into the public and find out a solution through mediation or recommendation. Which all the areas the ombudsman deals with? Yes. When there is poor service in the public sector like banking, insurance, and if there is any violation of the rights of people, there all the matters or the disputes arising from these all categories will be dealt with or will be dealing with the ombudsman. And we can say that this ombudsman is free from any executive influence. So students, now we will look into the terms, two important terms, that is banking ombudsman and insurance ombudsman. This is very important. And now first we will look into what is banking ombudsman. So banking ombudsman is a senior officer and he is appointed by RBI, Reserve Bank of India. And what is his duty? He has to listen to the complaints of the customers and to solve it. And these complaints will be regarding the poor service in the bank or about any deficiency from the bank side. And now we will look into what is banking ombudsman scheme. Banking ombudsman scheme means a fast and inexpensive forum to solve the complaints of the banking customers about the services related with banking, about the services related with banks. And this banking ombudsman initiated for the very first time in 1995 and it got amended in the following years 2006 and 2009. And the tenure of his office is banking ombudsman's office is for 3 years. Now we will check it out with what type of complaints this banking ombudsman is dealing with. If there is any refusal from the bank side to open a deposit account and the bank is not providing any valid reason for refusing not to open the account, we can approach the banking ombudsman. And if there is any non-payment or happening any extraordinary delay in clearing our checks, we can approach the banking ombudsman. And suppose if the bank refused to accept small denominations notes or coins. I think everybody is well aware with what is denominations uh, we wrote it in the checks. Okay, so non-acceptance of any small denomination notes or coins by the banking persons or banking officials without sufficient reason, and if they are charging any commission, if they accepted the small denomination notes and coins and if they are charging, we can approach banking ombudsman. If the officers are not available during the banking hours, we can file complaint about the officers in before the banking ombudsman. Now the complaints related with NRIs, of course, it goes to banking ombudsman, and then see, we all are well aware with imposing unwanted charges, and if the bank imposed any unwanted charges and they haven't noticed us about this unwanted or this unexpected charges, we can file a complaint before the ombudsman against the bank. And if there is any delay happening in the disbursement of pension, or if they are not at all paying the pension, we can the banking customers can approach the ombudsman. So these are the not all these complaints, because I didn't mention all the complaints. I mentioned some of them to get an awareness about what kind of complaints are being um, represented before the banking ombudsman. Now we will see the second term, that is insurance ombudsman. And this insurance ombudsman was established by the central government, and it was established in 11th November 1998. And the main purpose of the central government was to help the individual policyholders in solving their problem related with their insurance policy. And now we will check it out whether the policyholder can only file complaint. No. Um, a policyholder can file a complaint against an insurance company before insurance ombudsman, and at the same time his legal heirs can file complaint, his nominees can file complaint, or even his assignees, the person whom he assigned um, legally, can also file complaint on behalf of the policyholder against the insurance company. Now, this complaint need to be in writing, and this complaint should be present before the proper insurance ombudsman, because proper insurance ombudsman means the correct, it should be filed before the exact jurisdictional person. um, Now we check it out. Who can appoint the insurance ombudsman? It is a governing body of insurance council appoints the insurance ombudsman, and this insurance ombudsman committee includes one from LIC, one from Insurance Regulatory Development Authority, one from General Insurance Corporation of India, and a representative from the central government. And the insurance ombudsman should be one belongs to from an insurance company or judicial or civil services. And the term of the office of insurance ombudsman is for 3 years or up to the age of 65, which one is earlier. And no reappointment is permitted in the case of insurance ombudsman. Now we will look into the terms Lokpal and Lokayukta. So Lokpal means category of people and Lokayukta means appointed by the people. And this Lokpal is for the central and Lokayukta for the states. And the main aim of this Lokayukta and Lokpal is to eradicate corruption and bribery from the state. And both these institutions are established according to Lokpal and Lokayukta Act 2013. And we can say that all the public officers all the public officers will comes under the applicability of this Lokpal and Lokayukta Act 2013. But there are certain exceptions. We will check it out. What all are the exceptions? See, the current or the ex-prime ministers are excepted from the applicability of this act if they did something in relation with the international matters, external or internal security, or public order, atomic energy, or related with space. All these activities are excepted from the applicability of this act. So, like current and ex-prime ministers, ex-ministers and present ministers, and all the members of the parliament, present and previous, all are comes under the applicability of this Act. Here also there is exemption, and this exemption is according to Article 105 clause 2 of the Constitution of India. Now we will see what says in Article 105 clause 2. Article 105 clause 2 says that if a member of the parliament, if he did or said or cast his vote in the parliament or before any committee, as a member of the parliament, he is not liable to be get prosecuted before the court. If the member of the parliament did something or cast any vote in the parliament, cast a vote before the parliament or before any committee, as a member of the parliament, he is not liable to be get prosecuted before the court of law. If he made any publication of any paper under the authority of a member of a parliament, then also he is not supposed to get prosecuted before the court of law. So this exception mentioned in Article 105(2) of the Constitution of India protects ex-ministers, current ministers, ex-members, present members of the parliament from the applicability of this Lokpal and Lokayukta Act. Suppose an inquiry has been started. So before starting an inquiry against a public officer, consent of 2/3 members is necessary, and all the proceedings about the inquiry should be recorded with a camera. Suppose after the inquiry, if the concerned person found guilty and there necessitates a dismissal, the record of the inquiry should be made public and it should be available to the public. So now we will look into how Lokpal and Lokayukta Act 2013 is applicable for bureaucracy. Bureaucracy means the people comes under IAS and chief secretaries and public servants comes under each ministry of department. So under bureaucracy, the group mentioned in A, B, C and D in the Prevention and Corruption Act 1988 who is serving or has served in connection with the union will comes under the Lokpal and Lokayukta Act 2013. Now we will check it out who all included in the Lokpal. Lokpal will have a chairperson, and this person will be an ex-Chief Justice of India or ex-Judge of Supreme Court, or it could be or he or she could be an eminent juristic person. If the chairperson is an eminent juristic person, then there is an additional qualification like he should have at least not less than 25 years of experience in anti-corruption policy, public administration, vigilance and finance. And so Lokpal consists of a chairperson. Now the other members, and this other member should not exceed 18 number, and there is one more condition like out of these 8 members, 50% of the members, that means the 4% should be from the legal industry. And what all are the powers of Lokpal? The powers includes supervision, inquiry and investigation. For performing these powers, the Lokpal itself has an inquiry and prosecution wing to take care of the matters related with the public servants which were committed under the Prevention and Corruption Act 1988. Now this Lokpal has even recommend or direct the central government to constitute a separate court to conduct the cases related with this Prevention of Corruption Act 1988. So I already discussed that Lokpal is for the center, so Lokayukta are for for each states, and both these institutions were established as per Lokayukta and Lokpal Act 2013. But before enacting this act itself, the states like Kerala, Karnataka, and Delhi had institution of Lokayukta. It's really interesting, right? Yes. So this is all about conciliation, Lokayukta, Lok Adalat, then Lokpal, all these Ombudsman, everything. So this all comes under ADR. ADR means alternative dispute resolutions. So the second chapter is almost over. Now the students, if you need any clarification on any of the parts of this chapter, please make comment to me, and please do comment, or then I could help you in that particular topic.